98 through 102. One 24 to 127. One 38 to 140. And obviously they're not numbered as the state is going through and saying them, so that would require immediate to count, but I did want to try and give that at least as a heads up. Names certainly are used throughout. First names generally only unless it is the alleged victim's name in this case. But in terms of photos specifically that depict them, I wanted to at least give that heads up.
All right, thank you. And Ms. Stone, when we discussed this issue last week, you had estimated that potentially 2 hours for your closing. Do you believe that you can finish that many slides in 2 hours?
I think it is going to be very close. Certainly there's a number of, I would say photographs, video that take up a good portion of that, as I have identified. And there is overlap between several of the charges and evidence, so some of those go significantly faster. My hope is to be at 2 hours. I'm also trying to be mindful of not speaking too quickly. Sorry, I put a cough drop in this morning. I know that we have a new interpreter as well. The other interpreters that we've had throughout the trial have indicated that the pace has been fine. But if for some reason that changes, I would just hope that somebody would let me know so I can slow down. But my goal is to be done right at 2 hours. That's the state's intent.
All right. I estimate that it will probably take me about 40 minutes to read the 49 instructions to the jury. So we might be close to 10 o'clock by the time that I conclude. Once I conclude, I will give the jury a stand-up, move around little break. I don't want to interrupt anyone's closing, and I'll address this also with Mr. Keating and Mr. Leary. But I'm hopeful that you will have some sort of natural breaking place so we can take a 10-minute recess during your closing.
Yes, Your Honor. I think that I think there is a natural breaking or pause place so that way folks can get up, go use the restroom, whatever needs to be done.
All right. Thank you. Mr. Keating, do you have any preliminary issues this morning?
No, I was just going to ask about scheduling. Sounds like it's probably going to be just after lunch before defense will start. Is that the plan then?
That's my guess, just based upon the timing with the estimate for the length of the state's closing and taking into account the time it'll take me to read the instructions. I do, and presuming that's around noon, we'll recess for about 30 minutes. The jury will have lunch, and then we will bring them back in for to start with your closing. Also yesterday, you indicated, on Thursday, you indicated you believed 60 to 90 minutes for your closing. Is that still accurate?
I believe it is.
All right.
I think 60 is actually closer.
All right. So if it's 60, then I think that you just give your entire closing. If it's going to, as you're watching your time getting closer to 90, we may want to just take a stand-up break also, just to give them a little bit of a break. And then, Mr. Leary, I would anticipate taking a 10-minute recess after Mr. Keating's closing, so that, and then you would provide your closing. And depending on where we're at timing after your closing, whether or not I just do a stand-up before rebuttal or whether or not we take another 10-minute recess will just depend on where we're at. And you indicated that you believed probably around 60 minutes. Do you still believe that that is likely accurate?
Maybe a little bit over, but not much over. So.
All right. And same for you. If at some point you think it would be helpful to have a stand-up and take, a couple minutes, and or you think based upon it, the way everything else is going, that a 10-minute recess please feel free to indicate to me that you think it's a good time for a recess. I would do that.
I appreciate it.
All right, bring the jury in, please. Please be seated. Good morning, members of the jury, and welcome back. As I told you when we were last in court, what is left is for me to advise you as to the law that applies to this case, and that law is contained in the jury instructions. You have each been provided your own copy of the jury instructions. The only difference between what you have in front of you and what I have in front of me, the originals, which I have, are signed by me and dated with today's date, and the original instructions and the original verdict forms are printed on white paper. Everything that you have is on blue paper. After I read you the instructions, and I'm required to read them to you, then we will begin closing arguments. We do anticipate that closing arguments will take all day today. And as I told you previously, we have ordered or are ordering lunch, and we anticipate probably about a 30-minute lunch break. And we will still have a recess in the morning and a recess in the afternoon, but those might only be about 10 minutes each. All right. These are the court's instructions to the jury. Instruction number 1. It is your duty to decide the facts in this case based upon the evidence presented to you during this trial. It is also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proven, and in this way decide the case. Knowing that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberations consists of the testimony that you have heard from witnesses and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on that evidence. If I have ruled that any evidence is inadmissible or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that a witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in my instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by the lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on the lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express, by words or conduct, my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appeared to you that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely. You have nothing whatsoever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions. During your deliberations, you must consider the constructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. Instruction number 2. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors. Nor should you change your mind just for the purpose of reaching a verdict. Instruction number 3. A separate crime is charged in each count. You must separately decide each count charged against each defendant. Your verdict on one count as to one defendant should not control your verdict on any other count or as to any other defendant. Instruction number 4. Each defendant has entered a plea of not guilty. That plea puts in issue every element of each crime charged. The state is the plaintiff and has the burden of proving each element of each crime beyond a reasonable doubt. The defendants have no burden of proving that a reasonable doubt exists as to any of these elements. The defendants are presumed innocent. This presumption continues throughout the entire trial unless during your deliberations you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. Instruction number 5. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. Instruction number 6. A witness who has special training, education, or experience may be allowed to express an opinion in addition to giving testimony as to facts. You are not, however, required to accept his or her opinion. To determine the credibility and weight to be given to this type of evidence, you may consider, among other things, the education, training, experience, knowledge, and ability of the witness. You may also consider the reasons given for the opinion and the sources of his or her information, as well as considering the factors already given to you for evaluating the testimony of any other witness. Instruction number 7. A defendant is not required to testify. You may not use the fact that neither defendant has testified to infer guilt or to prejudice them in any way. Instruction number 8. You may consider a statement made out of court by one defendant as evidence against that defendant, but not as evidence against another defendant. Instruction number 9. A person commits the crime of murder in the second degree when with intent to cause the death of another person, but without premeditation, he or she causes the death of such person. Instruction number 10. A person commits the crime of attempted murder in the second degree when, with intent to commit that crime, he or she does any act that is a substantial step toward the commission of the crime. Instruction number 11. A substantial step is conduct that strongly indicates a criminal purpose and that is more than mere preparation. Instruction number 12. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Instruction number 13. A person is guilty of a crime if it is committed by the conduct of another person for which he or she is legally accountable. A person is legally accountable for the conduct of another person. He or she is an accomplice of such other person in the commission of the crime. A person is an accomplice in the commission of a crime if, with knowledge that it will promote or facilitate the commission of the crime, he or she either 1. Solicits, commands, encourages, or requests another person to commit the crime, or 2. Aids or agrees to aid another person in planning or committing the crime. The word aid means all assistance, whether given by words, acts, encouragement, support, or presence. A person who is present at the scene and ready to assist by his or her presence is aiding in the commission of the crime. However, more than mere presence and knowledge of the criminal activity of another must be shown to establish that a person present is an accomplice. A person who is an accomplice in the commission of a crime is guilty of that crime, whether present at the scene or not. Instruction number 14. The defendants are charged with attempted murder in the second degree. If the defendants were charged with the completed offense of murder in the second degree, the following elements would need to be proven beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant acted with intent to cause the death of Fatima Ali. 2. That Fatima Ali died as a result of the defendant's acts. And 3. That any of these acts occurred in the state of Washington. Instruction number 15. To convict the defendant Ihsan Ali of attempted murder in the second degree as set forth in count 1, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant did an act that was a substantial step toward the commission of murder in the second degree. 2. That the act was done with the intent to commit murder in the second degree. And 3. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 16. To convict the defendant Zahraa Ali of the crime of attempted murder in the second degree as set forth in count 1, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant, as a principal or as an accomplice, did an act that was a substantial step toward the commission of murder in the second degree. 2. That the act was done with intent to commit murder in the second degree. And 3. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 17. A person commits the crime of assault in the first degree when, with intent to inflict great bodily harm, he or she assaults another by any force or means likely to produce great bodily harm or death. Instruction number 18. An assault is an intentional touching or striking of another person that is harmful or offensive. A touching or striking is offensive if the touching or striking would offend an ordinary person who is not unduly sensitive. Instruction number 19. Great bodily harm means bodily injury that creates a probability of death or that causes significant serious permanent disfigurement, or that causes a significant permanent loss or impairment of the function of any bodily part or organ. Instruction number 20. To convict the defendant Ihsan Ali of the crime of assault in the first degree as charged in count 2, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant assaulted Fatima Ali. 2. That the assault was committed by a force or means likely to produce great bodily harm or death. 3. That the defendant acted with intent to inflict great bodily harm. And 4. That this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 21. A defense to the charge of assault, that the force used was lawful as defined in this instruction. The physical discipline of a child is lawful when it is reasonable and moderate and is inflicted by a parent for purposes of restraining or correcting the child. You must determine whether the force used, when viewed objectively, was reasonable and moderate. You may, but are not required to, infer that it is unreasonable to do the following acts to correct or restrain a child: throwing, kicking, burning, or cutting a child, striking a child with a closed fist, interfering with a child's breathing, doing an act that is likely to cause, and that does cause, bodily harm greater than transient pain or minor temporary marks. You shall consider the age, size, and condition of the child and the location of the injury when determining whether the bodily harm is reasonable or moderate. This inference is not binding on you, and it is for you to determine what weight, if any, such inference is to be given. The state bears the burden of proving beyond a reasonable doubt that the force used by the defendant was not lawful. If you find that the state has not proved the absence of this defense beyond a reasonable doubt, it will be your duty to return a verdict of not guilty as to this charge. Instruction number 22. The defendant is charged in count 2 with assault in the first degree. If, after full and careful deliberation on this charge, you are not satisfied beyond a reasonable doubt that the defendant is guilty, then you will consider whether the defendant is guilty of the lesser crime of assault in the second degree. If, after full and careful deliberation of the lesser charge of assault in the second degree, you are not satisfied beyond a reasonable doubt that the defendant is guilty, then you will consider whether the defendant is guilty of the lesser crime of assault in the fourth degree. When a crime has been proved against a person and there exists a reasonable doubt as to which of 2 or more degrees crime that person is guilty, he shall be convicted only of the lower degree. Instruction number 23. A person commits the crime of assault in the second degree when he or she intentionally assaults another and thereby recklessly inflicts substantial bodily harm or assaults another by strangulation. Instruction number 24. Strangulation means to compress a person's neck, thereby obstructing the person's blood flow or ability to breathe, or doing so with the intent to obstruct the person's blood flow or ability to breathe. Instruction number 25. A person is reckless or acts recklessly when he or she knows of and disregards a substantial risk that a wrongful act may occur, and this disregard is a gross deviation from conduct that a reasonable person would exercise in the same situation. When recklessness as to a particular fact is required to establish an element of a crime, the element is also established if a person acts intentionally or knowingly as to that fact. Instruction number 26. Substantial bodily harm means bodily injury that involves a temporary but substantial disfigurement or that causes a temporary substantial loss or impairment of the function of any bodily part or organ, or that causes a fracture of any bodily part. Instruction number 27. To convict the defendant of the crime of assault in the second degree, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, defendant A intentionally assaulted Fatima Ali and thereby recklessly inflicted substantial bodily harm, or B, intentionally assaulted Fatima Ali by strangulation, and 2, that this act occurred in the state of Washington. If you find from the evidence that element 2 and either alternative element 1A or 1B have been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. To return a verdict of guilty, the jury need not be unanimous as to which of alternatives 1A or 1B has been proved beyond a reasonable doubt, as long as each juror finds that either 1A or 1B has been proved beyond a reasonable doubt. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to either elements 1 or 2, then it will be your duty to return a verdict of not guilty. Instruction number 28. A person commits the crime of assault in the 4th degree when he commits an assault. Instruction number 29. To convict the defendant Ihsan Ali of the lesser included crime of assault in the 4th degree, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant intentionally assaulted Fatima Ali, and 2, that this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 30. To convict the defendant Zahraa crime of assault in the 2nd degree as charged in count 2, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant intentionally assaulted Fatima Ali by strangulation. And 2. That this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 31. A person commits the crime of unlawful imprisonment when he or she knowingly restrains the movements of another person in a manner that substantially interferes with the other person's liberty, if the restraint is without legal authority and without the other person's consent, and the person knows that the restraint is without legal authority and without the other person's consent. Instruction number 32. A person knows or acts knowingly or with knowledge with respect to a fact, circumstance, or result when he or she is aware of that fact, circumstance, or result. It is not necessary that the person know that the fact, circumstance, or result is defined by law as being unlawful or an element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. When acting knowingly as to a particular fact is required to establish an element of a crime, the element is also established if a person acts intentionally as to that fact. Instruction number 33. Restraint is without consent if it is accomplished by physical force, intimidation, or deception. Instruction number 34. To convict the defendant Ihsan the crime of unlawful imprisonment as charged in count 3, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant knowingly restrained the movements of Fatima Ali in a manner that substantially interfered with her liberty. 2. That such restraint was without Fatima Ali's consent. 3. The defendant knew that such restraint was without Fatima Ali's consent. 4. That such restraint was without legal authority. 5. That the defendant knew that such restraint was without legal authority. And 6. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 35. To convict the defendant Zahraa crime of unlawful imprisonment as charged in count 3, each of the following 6 elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant, as a principal or as an accomplice, knowingly restrained the movement of Fatima Ali in a manner that substantially interfered with her liberty. 2. That such restraint was without Fatima Ali's consent. 3. That the defendant knew that such restraint was without Fatima Ali's consent. 4. That such restraint was without legal authority. 5. That the defendant knew that such restraint was without legal authority. And 6. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 36. Family or household member means a persons who have a biological or legal parent-child relationship, including step-parents and stepchildren, and grandparents and grandchildren. Instruction number 37. It is a defense to a charge of assault in the 4th degree as charged in count 4 as to Ihsan Ali that the force used was lawful as defined in this instruction. The use of force upon or toward the person of another is lawful when used by a person who reasonably believes that he is about to be injured in preventing or attempting to prevent an offense against the person, and when the force is not more than is necessary. The person using the force may employ such force and means as a reasonably prudent person would use under the same or similar conditions as they appeared to the person, taking into consideration all of the facts and circumstances known to the person at the time of and prior to the incident. The state has the burden of being beyond a reasonable doubt that the force used by the defendant was not lawful. If you find that the state has not proved the absence of this defense beyond a reasonable doubt, then it will be your duty to return a verdict of not guilty as to this charge. Instruction number 38. Necessary means that under the circumstances as they reasonably appeared to the actor at the time, 1. No reasonably effective alternative to the use of force appeared to exist, and 2. The amount of force used was reasonable to effect the lawful purpose intended. Instruction number 39. It is lawful for a person who is in a place where that person has a right to be and who has reasonable grounds for believing that he is being attacked to stand his ground and defend against such attack by the use of lawful force. The law does not impose a duty to retreat. Notwithstanding the requirement that lawful force may be not more than is necessary, the law does not impose a duty to retreat. Retreat should not be considered by you as a reasonably effective alternative. Instruction number 40. No person may, by an intentional act reasonably likely to provoke a belligerent response, create a necessity for acting in self-defense, and thereupon use or attempt to use force upon or toward another person. Therefore, if you find beyond reasonable doubt that the defendant was the aggressor and that the defendant's acts and conduct provoked or commenced the fight, then self-defense is not available as a defense. Instruction number 41. To convict the defendant Ihsan Ali of the crime of assault in the 4th degree as charged in count 4, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant assaulted Isaiah Williams. That this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 42. A person commits the crime of burglary in the 2nd degree when he or she enters or remains unlawfully in a building with intent to commit a crime against a person or property therein. Instruction number 43. A person enters or remains unlawfully in or upon premises when she is not then licensed, invited, or otherwise privileged to so enter or remain. A license or privilege to enter or remain in a building that is only partly open to the public is not a license or privilege to enter or remain in that part of the building that is not open to the public. Instruction number 44. A person who enters or remains unlawfully in a building may be inferred to have acted with intent to commit a crime against a person or property therein. This inference is not binding upon you, and it is for you to determine what weight, if any, such inference is to be given. Instruction number 45. The term premises includes any building, dwelling, or any real property. Instruction number 46. To convict the defendant Zahraa Ali of the crime of burglary in the second degree as charged in count 4, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant entered or remained unlawfully in a building. 2. That the entering or remaining was with intent to commit a crime against a person or property therein. And 3, that this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 47. A person commits the crime of violation of a court order when she knows of the existence of a protection order and knowingly violates restraint provisions of the order prohibiting contact with the protected party, or a provision of the order excluding the person from a school, or a provision of the order prohibiting the person from knowingly coming within or remaining within a specified distance of a location. Instruction number 48. To convict the defendant Zahraa Ali of the crime of violation of a court order as charged in count 5, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, there existed a protection order applicable to the defendant. 2. That the defendant knew of the existence of the order. 3. That on or about said date, the defendant knowingly violated a restraint provision of the order prohibiting contact with a protected party, or provision of the order excluding the defendant from a school, or a provision of the order prohibiting the defendant from knowingly coming within or remaining within a specified distance of a location. And 4, that the defendant's act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 49. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 12 jurors are present. You are all officers of the court and must evaluate the evidence with an open mind free of bias or prejudice. If during your deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes that you have taken during the trial if you wish. You have been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. If after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly. For this purpose, use the form provided in the jury room. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to the bailiff. I will confer with the lawyers to determine what response, if any, can be given. You will be given the exhibits admitted in evidence, these instructions, and verdicts forms A, B, BB, BBB, C, and D for the defendant Ihsan Ali, and verdict forms A, B, C, D, and E for defendant Zahraa Ali. Some exhibits and visual aids may have been used in court, but will not go with you to the jury room. The exhibits that have been admitted into evidence will be available to you in the jury room. When completing the verdict form for count 2 for the defendant Ihsan Ali, you will first consider the crime of assault in the first degree as charged. If you unanimously agree on a verdict, you must fill in the blank provided in verdict form B the words "not guilty" or the word "guilty" according to the decision you reach. If you cannot agree on a verdict, do not fill in the blank provided in verdict form B. If you find the defendant Ihsan Ali guilty on verdict form B, do not use verdict form BB. If you find the defendant Ihsan Ali not guilty of the crime of assault in the first degree, or if after full and careful consideration of the evidence you cannot agree on that crime, you will consider the lesser crime of assault in the second degree. If you unanimously agree on a verdict, you must fill in the blank provided in verdict form BB the words "not guilty" or the word "guilty" according to the decision you reach. If you cannot agree on a verdict, do not fill in the blank provided in verdict form BB. If you find the defendant Ihsan Ali guilty on verdict form B or BB, do not use verdict form BBB. If you find the defendant Ihsan Ali not guilty of the lesser crime of assault in the second degree, or if after full and careful consideration of the evidence you cannot agree on that crime, you will consider the lesser crime of assault in the fourth degree. If you unanimously agree on a verdict, you must fill in the blank provided in verdict form BBB the words "not guilty" or the words "guilty" according to the decision you reach. If you cannot agree on a verdict, do not fill in the blank provided in verdict form BBB. You will also be given special verdict forms A1, B1, BB1, BBB1, and C1 for defendant Ihsan Ali for the crimes charged in counts 1, 2, and 3. If you find the defendant not guilty of these crimes, do not use the special verdict forms. If you find a defendant guilty of these crimes, you will then use the special verdict forms and fill in the blanks with the answer yes or no according to the decision you reach. In order to answer special verdict form yes, you must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer. If you unanimously agree that the answer to the question is no, then you must fill in the blank with the answer no. If after full and fair consideration of the evidence you are not in agreement as to the answer, then do not fill in the blank for that question. You will also be given special verdict forms A1, B1, and C1 for defendant Zahraa Ali for the crimes charged in counts 1, 2, and 3. If you find the defendant not guilty of these crimes, do not use the special verdict forms. If you find a defendant guilty of these crimes, you will then use the special verdict forms and fill in the blank with the answer yes or no according to the decision you reach. In order to answer the special verdict form yes, you must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer. If you unanimously agree that the answer to the question is no, then you must fill in the blank with the answer no. If after full and fair consideration of the evidence, you are in agreement as to the answer, then do not fill in the blank for that question. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the proper form of verdict or verdicts to express your decision. The presiding juror must sign the verdict forms and notify the bailiff. The bailiff will bring you into court to declare your verdict. The following pages after instruction 49 are the verdict forms that I have referenced. Members of the jury, we're going to just do a quick little stand up and then we'll start the closing arguments. All right, we'll have everyone have a seat. Members of the jury, if you would please give your full attention to Ms. Stone as she makes closing argument on behalf of the plaintiff, the state of Washington.
Counsel, ladies and gentlemen, so a couple of weeks ago when we came in and we started this, we indicated you would be here for several weeks, and there was a lot of information that you were going to get. We have reached that point where you've now been informed on the law by the court. You have a fairly lengthy packet of instructions, and you've heard a lot of evidence over the course of the last several weeks. I will tell you that there is no fast way to get through all of that evidence and compare it to the instructions. The court, I think, has informed you, and you'll hear it again. The state has the burden. That is properly the state's burden, and the state accepts that burden. But what that means is I am responsible for proving to you every element of every crime that has been charged. So we have to take some time to do that. And then at the end of this, because it's the state's burden, we get to talk to you again. I promise you the second time will be much shorter. But if at any point during the course of this, someone needs a break, you can't hear something, you just need to stand up, please catch our attention. We will plan to take a break, but we want to make sure that if someone needs that earlier, you let us know, okay? So I have slides. Everybody processes information differently. Lots of you take notes. You can see that the attorneys take a lot of notes too. Some folks are much more auditory processors, and some folks are very visual processors. So I've tried to give you a number of different ways, as the court has during the course of this as well, of processing that information. If slides do not work for you, then please ignore them and don't pay attention to them. It helps me stay on track. It helps me present it in a more organized fashion, but that may not work for everyone else, okay? So don't feel like you have to pay attention just because they are there. Make sure that, there we go. So I always start with this first slide, lawyer statements. Lawyers talk a lot, right? It's what we do. You are going to hear from the group of us, first myself, then Mr. Kading, then Mr. Leary, and then me again. What we tell you is not evidence. The evidence is the testimony and the exhibits that came from individuals that were sitting in that seat over there. The attorneys will tell you things. We will argue to you the evidence we believe that you have heard over the course of the last several weeks. Attorneys are human too, and whether it is myself or Mr. Kading or Mr. Lee, what we tell you is not evidence. So if we misspeak, if we say something that we believe a witness has said or we recall a witness having said, and that does not jive with your memory of those events or your notes or your recollection, your memory, your notes is what the evidence is. We are not the triers of fact. We are just the attorneys, okay? So please rely on the instructions you've been given by the court and your recollection in those notes. So evaluation of the evidence. We provide this instruction also as well. Oftentimes you will hear folks during the course of whether it's a TV show or an argument or something else, was just circumstantial evidence. It doesn't mean anything. That's an inaccurate statement. When you come in, at least in the state of Washington, when you come in here, you do not come in here in a vacuum of life experiences. We want a fair and impartial jury, both for the state and for the Ollies. We want to ensure that that is what you are there to do, but we do not assume that you have no life experiences and you cannot process information about what is reasonable behavior, what is unreasonable behavior, and reasonable inferences to take from those. So in Washington, we give you that distinction between direct and circumstantial evidence. Direct evidence is that thing that you have directly perceived. Circumstantial evidence is the thing you know and you can make a reasonable inference from. So let me give you an example of that. And we use a cake example very often, right? If you go in and you make a cake, everyone who's ever made a cake knows you cannot frost a hot cake, right? My bakers know that. That frosting is going to slide right off the side and be a gooey puddle. It will look nothing like what it's supposed to do. So if you make your cake, you have to let it sit out and cool. So now let's say that you've made that cake. It is sitting out, it's cooling, and you live alone, you live with your dog, and you have errands to run. So you lock your doors, your windows are all locked, nobody else is there. You come back a couple hours later, and what was once a beautiful cake waiting to be frosted is now in shambles on the floor. There's crumbs everywhere, your dog looks comfortably full, and there's crumbs all over the dog's face. Direct evidence would have been a video watching your dog eat that cake. Circumstantial evidence is exactly what we've just described. You know your dog ate the cake. That is the only reasonable inference that comes from that evidence. You didn't see it, but you know that that's what happened. There's no other reasonable explanation. No one's broke in. You said no one lives there. There's no windows. That's what happened to your cake. That is circumstantial evidence. And that is in large part why we provide you this instruction, but we trust that you are going to use your rational mindset and your common experience to know what facts and inferences to take from the evidence that you see. There may be differences in types of evidence that you receive, but the fact that one is circumstantial and one is direct makes no difference in terms of the weight that you give it, just by definition. So please don't get stuck in that loop in deliberation, like, well, it was only circumstantial, or oh, it was direct, so that's better than this kind. That's not the case. Like I say, that individual piece of evidence may have a different weight, but that weight is not drawn from whether it is a piece of direct evidence or a piece of circumstantial evidence, okay? So evaluation of the witness testimony. Our way through those. In addition to the fact that you are the triers of fact, the sole triers of fact, you are also the sole judges of credibility. The attorneys are not. We cannot comment on the credibility of witnesses. We can point out whether there was a particular manner about a witness testifying, whether there was a personal interest, whether there's a reasonableness of the statements that they may have provided to you in context of everything else that you saw, but you are the sole judges of credibility. So when you are looking at the testimony of witnesses and how to evaluate that, you are given an instruction about some of the things that you can look at to help assist you in that process, okay? Reasonable doubt. Before you came into trial, if you've never sat on a jury before, but before you came in here, I believe that you would probably describe yourself as reasonable people. Most people would describe themselves as reasonable people. Having sat in here now and gone through all of these instructions, I would submit to you that we have ruined you with the law. You are no longer reasonable people. When you go back home and you're talking to friends, when this is all over, or talking to your family, when the court has released you from your instructions not to talk about it, you can say, well, I don't know, I had a reasonable doubt. We didn't convict on A, B, and C, or at all because I had a reasonable doubt. Or we convicted them on A, B, and C, or we convicted them on all because we had an abiding belief in the truth of the charge. Nobody talks like that. Lawyers talk like that, right? But now you will talk like that, at least as you're evaluating this and in talking to each other in that back room. So what does reasonable doubt mean? And you have the instruction. I submit to you that reasonable doubt and abiding belief are two sides of the same coin. If you have an abiding belief, then you do not have a reasonable doubt as to the truth of the charge. An abiding belief is abiding, long-lasting. You believe it today, you believe it tomorrow, you believe it next week, next month, next year. That is an abiding belief in the truth of the charge, that the defendant did what the state has charged them with, and that the state proven that beyond a reasonable doubt. You have an abiding belief. If you have a reasonable doubt, then you cannot have an abiding belief in that truth of that charge. Right? So it is not, there's no numeric value that you can apply to it. It's not a 51% or a 75%. Reasonable doubt is one of the highest standards certainly that we have, and we talked about that during voir dire, but it is not 100% either. So there is no numeric value associated with reasonable doubt. But as it says, if you have an abiding belief in the truth of the charge, then you do not have a reasonable doubt. And it's just another way of, I think, talking about that and evaluating within yourself. It's kind of, amorphous is not the right word, but we as humans really like objective measurements, and there's no objective measurement associated with reasonable doubt. So you really have to look at this standard as you're talking about it and thinking about it amongst yourselves. It has been achieved, okay? Things you will not get. The court told you this just now in the instructions. Ms. Zoe talked to you about it during opening arguments, or excuse me, opening statements, if you recall. You are not going to get certain documents. And that I know is frustrating every time for a jury because people have referenced them. But the reason that you don't get them is exactly what we talked about, because the testimony is the evidence. A police report is not evidence. If that were the case, we wouldn't call anyone into court. You wouldn't hear from witnesses ever. We'd have them write a statement, you'd have police reports, you'd get doctor's reports, and you would never have anyone come in and testify. The law, we value the testimony of people who are coming to tell you what they saw, what they heard, what they observed, what happened related to these events. And that is why the testimony comes from the person sitting in that stand. That's why you don't get police reports that officers have made along the way. You're not getting medical reports because the doctors came and told you what is contained within those reports and told you what they observed. Prior statements of witnesses, you don't get those either, right? That's why we have cross-examination, why we have direct examination. So please don't ask for them because they are not coming. You have to make your decisions based on the information that you have heard and what you have received as exhibits, and as we go through this process, right, talking to each other. And then last, of course, transcripts of any trial testimony. You're not getting any transcripts of, can we get a transcript of what so-and-so said on such and such day? That's not coming either, okay? So as you are going through and organizing your thoughts, please keep that in mind. There's a lot of overlap. So I'm going to tell you that there is approximately, if I did my math right, 11 different crimes that I have to go through and describe to you. There's a lot of overlap in that evidence. So I've tried to break it down as we go through those crimes where there is a overlap between both parents, and then we'll separate out some of the parents. So let's start first with count number 1, attempted murder in the second degree of that victim, Fatima Ali, for both parents, Ihsan and Zahraa Ali. Attempted murder in the second degree. I think it's instruction 14, I believe, gives you what it looks like if there is a completed murder in the second degree. Please do not get caught up in that is what the state has to prove. That is not the case. Instruction 14 shows you what completed murder in the second degree would look like. Instruction number 15 tells you what attempted murder looks like. If they were to have done this and completed it, this is what the state would have to prove. Instruction 15, I believe, is the one that says, but here are the actual elements that the state must prove, and that is a substantial step. A substantial step needs to occur. So a person commits the crime of attempted murder in the second degree with intent to commit that crime. He or she does any act that is a substantial step toward the commission of that crime, okay? There is the completed murder in the second degree. A person commits the crime of murder in the second degree when, with intent to cause the death of another person, but without premeditation, he or she causes the death of such person. Then you are given what I'll call a bunch of definitional instructions. This one is as to the mental state. So intent, a person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Here's your definition for substantial step. A substantial step is conduct that strongly indicates a criminal purpose and that is more than mere preparation. It's not simply thought, but it is an act in furtherance of that intent. So these are what we talked about initially. The defendants are charged with attempted murder if, and I don't know that my red, it's a giant red dot, so you can see the if underneath, right? If the defendants were charged with a completed offense, this is what the state would have to prove, right? But because it is attempted, this is what the state actually has to prove. That on or about October 18th, the defendant did an act that was a substantial step toward the commission of murder in the second degree, that the act was done with the intent to commit murder in the second degree, and that any of these acts occurred in the state of Washington. And then when we talk about Zahraa Ali, the only difference between Ihsan and Zahraa is that Zahraa is charged as a principal or as an accomplice. Ihsan is only charged as a principal. Zahraa is charged in both fashions. So principal, you do it yourself without any help, or accomplice, that you were doing it to assist. You were assisting another in reaching their goal. So let's talk first about elements 1 and 3 for both parents. When we talk about elements 1 and 3, there's going to be, as I said, overlap. These are the elements that I anticipate there's not going to be a lot of argument from. I still have to prove them to you. The state still has, beyond a reasonable doubt, responsibility for proving these, but defense counsel, I don't believe is likely to argue that it didn't happen on October 18th and it didn't happen in the state of Washington. So here's the evidence that applies for each of those, right? All testimony agrees that this was Friday, October 18th, 2024. You have the bus and the body cam videos that you saw that confirmed that, and then you have the testimony of the date and time of those school videos that Celeste Waltermeyer. When we pull it and download it, those dates are not shown on that video, but that's specifically the date, time, range that I was looking and pulling from. And that information that you see in context on those school videos themselves from Timberline High School are consistent with what you see in context from all of the other videos. So I submit that that's accurate. She didn't pull a different date or a different time, right? Element 3, that these acts occurred in the state of Washington. This is Timberline High School. That testimony occurred over and over again. 6120 Mullen Road, Southeast, Lacey, Washington. And all of that testimony confirms the same. You're going to see this, a variation of this slide, a number of times because it applies to every single count that we have, okay? So, again, what exhibits do we have that demonstrate that as well? Here is exhibit 1. You have that bigger aerial photo. You have Timberline High School. You have the parking lot here. Now my red dot is covering towards the bottom center of that page where that bus stop is, and you have Mullen Road that runs diagonal across that page. Exhibit 2, bigger shot of the same thing. Again, bottom left corner, you have that bus stop identified. Mullen Road is identified. You can see that parking lot that we've watched several videos of throughout this trial. And you can see the crosswalk running diagonal across the parking lot, but almost directly perpendicular up and down on this page with the white dashes running across it just to the left of center. Right? That's the crosswalk that we observe Fatima and Isaac during the course walking to the bus stop, and then again people describing later towards the Timberline High School, which is outside of this photo but would be at the very top of it, right? That's where those front doors are. So then we talk about let's talk about the rest of element 1, right? Remember, element 1 under attempted murder has a couple of different things within that element itself it has to prove. So the rest of element 1, speaking first to Ihsan Ali did an act that was a substantial step toward the commission of murder in the second degree. So what evidence do you have of that? What facts did you hear during the course of this trial? First, you have that he grabs Fatima by the hoodie and places her in a rear naked choke. Let's be clear, the state is not asserting that Ihsan Ali showed up on that day with the intent to try and kill his daughter. There was no premeditation that the state is asserting, but by the time Ihsan goes into these events, the state's position is that that has changed. His intent has substantively changed. He grabs her by the hoodie and he places her in a rear naked choke, and we've heard that described with specificity. He takes her to the ground. He holds her in that choke for an extended period of time. He ignores those repeated screams and demands of no less than 6 kids. There's probably more at varying times, but there's approximately 6 that are there pretty consistently throughout that entire process. And 2 separate adults to release her. We see Mr. Denicola come up on the scene in his bright orange vest. We see later Josh Wagner arrive on scene, and they're all saying the same thing. They're all screaming at him to release her, to let her go. Denicola, I think even at one point, I submit when you watch that video, is pointing a finger, and he's telling you, he told you in his testimony, I was telling him to let her go, to release her, to let her go, and he was just doing nothing. He was ignoring me. So it's not just kids that are running around. There's no chaotic panic. These are adults that are watching it happen and very clearly know that this is wrong. They're screaming that she can't breathe and he's killing her. And you hear that on the video. He continues to hold her while she fights and struggles. There's an apparent seizure. She goes limp, and then she is unconscious. The testimony by everyone is that her eyes have rolled back in her head, her face is pale, her lips are blue, and I believe Josh Wagner says she has changed colors. When asked on direct examination, Mr. Wagner, based on what you observed, and you came to it towards the end, based on what you observed, is there any way that could have been confused with hugging or simply restraining that child? And his response is no, it's very obvious she was being choked. That was Josh Wagner's statement. And then you have Exhibit 61, which is Elijah's video, that shows you exactly the same thing. So I submit to you that that substantial step towards murder in the second degree has been taken. So then element 2, that the act was done with the intent to commit murder in the second degree. So what evidence have you heard throughout this trial that shows that? First, he holds her throughout all of that and continues to hold her after. The only time he releases her is when Josh to release her. All of these things are happening. This is not a like, oh gosh, it happened so fast, I had no idea what to do. It is an extended period of time, and he continues to hold her. Denicola, remember, he testifies that his arm is straining around her neck, that Ihsan's arm is clearly, there is a tension there. His hands are locked. Mr. Denicola's statement was, when asked, well, how do you know, what did that look like? And he was like, it was the look on his face. So he is there with them on the ground, and Ihsan's face clearly demonstrates to Mr. Denicola the intent behind what Ihsan Ali is doing to his child. It is so upsetting, in fact, Mr. Denicola testifies towards the end, that he calls his supervisor to call it in, and he says he is in shock. He's trying to process what he just saw, and he has to pull the bus over on the side of the road, and his supervisor has to come take his route. That is how upsetting this group of kids that are just overreacting to a situation, that is how upsetting that event was to Mr. Denicola. And he's described, I have security camera on my bus. I've had to look for a bunch of things. Fights, whatever. He had to pull his bus over to process what he saw here because it was so upsetting. So what does that tell you? How is this different from the objective observer that doesn't know any of these individuals from Adam about what he observed from Mr. Ali's intent, that it was an intent to commit murder?
not something else. You have Caleb talks to you about we're trying to get him off. In fact, I'm pulling so hard at his arms that he tears Isan's coat, and still he doesn't release. Nothing changes, and you see evidence of that coat tear later. It is shredded down his arm. Isan doesn't let go. He is holding on to Fatima's neck throughout. He releases only when he is physically forced to do so, despite, and go back and watch the video I submit to you, she has stopped struggling for approximately 15 to 18 seconds prior. She's unconscious, and he continues to strangle her around the neck for another 15 to 18 seconds, and would have continued to do so even longer before the intervention of those adults. Then you have Dr. Gilbert's testimony about the effects of strangulation on the body, what happens, and why that happens. She talked to you about the jugular vein inclusion, carotid artery inclusion, and tracheal inclusion. Remember? The lack of, starting first with jugular vein inclusion, the lack of removal of deoxygenated blood. Those are those thin-walled veins on the outside of your neck, right? You need the bad blood to come out of your brain so your brain can function. And we'll come back to the pressure, but it's about 4 pounds of pressure for that jugular vein inclusion, one on each side, thin walls. Then she talked about the lack of oxygenated blood to your brain. That is that carotid artery occlusion. Those are thicker walled arteries, and they are deeper within your neck, right? And that is greater pressure to close. She said about 11 pounds, I believe. And then she talks about what that lack of oxygen to the brain and that buildup of pressure does in the brain, how that leads to brain death, which is death. So then we talk about element number 1 for Zahraa, as a principal or as an accomplice. So remember first, this is generally speaking what it means, that language principal or accomplice means. All assistance by words, acts, support, or presence, and present at the scene and ready to assist. First we have, well, let me back up for one moment. When we talk about principal or accomplice, it's really obvious what a principal is, right? You're the person doing it, you don't have any help, you're doing it sort of independently yourself. As an accomplice, if you're assisting someone else. And we distinguish, I'll give you a bank robbery as kind of the classic example. When we distinguish an accomplice in like a bank robbery identification, right? We want to talk about the people that are there to help assist the principal in doing whatever the principal is doing, robbing the bank. We want to distinguish that person from the customers that are present, that are there to do business. They know bank robbery is happening. They're present and they're aware, but certainly we wouldn't identify the customers as accomplices in that case. We would identify the getaway driver, the lookout, the other person who's providing the banking information or copies of the key. We would describe those people as accomplices. And even the lookout, right? They may not even actively touch anything. They may literally just stand at the door, but they are still identified as an accomplice. So that accomplice liability instruction, and you have it in your instructions, I don't recall the number off the top of my head, but that is what distinguishes somebody who's just present and has knowledge of what's going on from the person who is actively engaged in trying to fulfill the goal or extend the behaviors of the principal, right? All assistance by words, acts, support, or presence, and present at the scene and ready to assist. That is your accomplice liability instruction. So what do you have? You have Exhibit 34 at 2:13:57 on Exhibit 34, and that's that the bus video, the road view of that bus video. Mrs. Ali arrives at that tree. Josh Wagner, white line, he's still in the street on Mullen Road. Isan is struggling with Fatima, but Zahraa is already there. She is a couple steps ahead of Josh Wagner. 2 seconds later, same exhibit, you see that Zahraa is at the group. She's bent down with Fatima. Her arms are outstretched. Josh Wagner has just reached the dirt. He's not even at the group yet. So he's not there. He hasn't interrupted the strangling, but Zahraa is there, and Zahraa's not like somewhere else. Zahraa is right there. She is bent down with those individuals. These are separate acts and behaviors from those of the kids watching, because what are the kids doing? The kids are still screaming, get off of her, let go of her, you're killing her. And what does Mary Wagner say? Mary Wagner says, Zahraa is not helping the young woman on the ground. She seems to only be trying to stop the teens from hitting the man who is strangling Fatima. She did nothing to assist Fatima from what Mary Wagner saw. That's, I submit to you, what you see on the video. It's fast. Remember that those videos go, they pause, they go in slow motion, and you have access to those to fully and fairly consider that. But she goes in and she immediately is pushing kids, but she's not providing assistance to Fatima. Neither Josh Wagner or Denicola describe any assistance for dislodging Fatima by any other adults. They're the only two that are in there trying to get Ihsan Ali's arms pried off of the neck of his daughter. No one else, in terms of adults, are doing that. Then you have Exhibit 122 plus Mrs. Ali's statements. She clearly expresses over and over again to law enforcement that her concern is for the kids that are hitting and striking her husband, not Fatima. In fact, she doesn't even mention that her husband has been strangling Fatima. But she's there. We know she sees it. Everybody else sees it. But she says not a word about how her child has been strangled into unconsciousness. And we know by the time she arrives, Fatima is unconscious. She is pale, her lips are blue, and she is laying still, because there's only about a handful of time from the time that she gets there to the time Josh Wagner is able to get Fatima released. And what does Josh Wagner say? He immediately knows that a child is being choked. He doesn't say, when I got up, I could see that it was a child being choked. When I got out of the car and started coming across the street, I could immediately see this is a child that is being strangled. Immediately. And again, he doesn't know these individuals from Adam, but Mrs. Ali does. In fact, she's outside of Isaiah, is really the only one who knows exactly who is strangling and who is being strangled. And she doesn't mention a word to law enforcement. Remember what Officer Bell says. When asked, how long until you knew? He was like, at the end. It was basically to the end of my time there on scene before I had any idea that Fatima had been strangled. Because even though I had talked to mom and had interactions with mom, she didn't say anything about it. Not a thing. So we have to go through the accomplice liability and the principal for Zahraa. So element 1, as an accomplice. What evidence do you have? As an accomplice, at 2:13:55 into that exhibit. And remember, that's the date time. In exhibit 34, it has the date time stamp on the bottom. So 2:13:55, Fatima goes unconscious. So we know she's already in that state by the time mom gets there. Her face is pale, her lips are blue. Ihsan is still actively strangling Fatima at that time. We said she knows what's going on because it's apparent to everyone else, immediately apparent to everyone else. And Zahraa is the only one that knows those individuals. And that she's attempting to intervene on behalf of her husband while he is still actively choking Fatima. Not Fatima. She's not attempting to intervene on behalf of Fatima. That is a substantial step. That is more than your presence and knowledge at that scene. We know that Fatima is not released by Ihsan until about 2:14, 10 to 13. So that if you look at that video and watch, somewhere between 10 seconds after and 13 seconds after, that is when we know Fatima gets released. So there's a period of about 11 to 14 seconds where mom is assisting Ihsan and not Fatima by trying to prevent assistance to Fatima from those kids. So again, as an accomplice, element 2 for Zahraa, that it was done with the intent murder in the second degree. that she is actively watching her husband strangle her child in that rear naked choke with the arms tightly locked around her child's neck. She is actively able to see what every other person has described as Fatima's appearance throughout that time. She has time to view the situation and make a decision to try and remove impediments and prevent injuries to her husband. So we know she's able to quickly evaluate a situation and take actions based on her evaluations. To be clear, this is not a complicated fact pattern to evaluate when you have arrived on that scene. Everybody says so. Everyone that's present says so. Every other person immediately knows the danger, obvious danger of death to Fatima, but somehow mom doesn't. So what do we take from this? Her loyalty is to her husband and his purpose, not to her child. So then as a principal, what is the substantial step, the evidence you have of a mom as a principal? She's just watched her child being choked and unconscious for approximately 11 to 13, 14 seconds per that bus camera video. Fatima is then released. Josh Wagner gets her released. She is incoherent. Remember what Fatima says. The last thing she sees, remember seeing is Isaiah on her face and bushes, and the next thing she knows, she is in her mom's arms, and her mom has her arm around her neck. She is not there. Mary Wagner talks about that, like, that girl is not there. Like, I don't have another way to describe that. She just was clearly not aware of what is happening around her. She has come out of that unconsciousness. But she immediately wraps her arms around Fatima's neck. Her ability to breathe, Fatima says, I can't breathe. I'm trying to tell my mom, but everyone describes like nothing is coming out. There's no sound coming out. Denicola says he remembers hearing her being almost like raspy, whispery, but she wasn't really making sound. And plainly he said, I wasn't looking at that. I saw what appeared would be a mom and the child, so I assumed they were fine. My focus is on dad because that's where the immediate threat was. And I was trying to pay attention to the immediate threat. But I remember hearing this very whispery, raspy. That is consistent with what Fatima told you that she was trying to do. Trying to tell her mom, I can't breathe. And her mom doesn't let her go. So what happens? Then the kids intervene as well. That's the substantial step. Dr. Gilbert, again, all of that same information about the effects of strangulation on the body and why. And certainly, if you've just been strangled for 45 seconds, being strangled a second time doesn't improve that condition. You don't start over from zero as if the first time it never happened. It is a continuation of that strangulation. So what is the information that the act was done with the intent to commit murder? Same intent as accomplice liability. That hasn't changed. She has actively watched her husband strangle her child. She's actively able to see what everyone else has described. She's had time to view that situation and make decisions to try and remove those impediments to her husband and prevent injuries. And she's had, at this point, when she is separately strangling her daughter, has even more time now, knows the danger, and does it anyway. She does it anyway. That is not an effort to comfort her child. Again, that is not where her loyalty lies in this situation. And she demonstrates that over and over and over again during the course of those videos. So here is that bus video. I'm going to play it in regular speed. You can play it whatever speed you want. This is what you see from the backside, right? They've now run away. And this is the face of Isaiah and Fatima as they are running to the school for help. That is not the face, I submit to you, of children who are just goofing off, who just believe that they are trying to get away from their parents because they're going to get in trouble. Evaluate what that face looks like as Fatima's running away from her parents. Look at Fatima's face when she comes in Exhibit 111, page 3 of that, because it comes in a packet of still shots. Look at Fatima's face when she comes in that office. You heard Tracy Arnold testify that she looked like she was in terror. She was frantic. Submit to you that is consistent with what Exhibit 111 presents. Now you also have a instruction attached to a special verdict form. Everything that is a -1, essentially, in your packet. You have a lot of verdict forms, you guys. Everything that is a -1 is what we'll refer to as a special verdict form, and you have to just answer yes or no. And that is, essentially is, depending on which count it is Ihsan a family or household member, or is Zahraa a family or household member of Fatima? And here is the instruction that describes what a family or household member is. It's exactly what you would think it is, right? If you are a biological or legal parent-child relationship. So in terms of the elements, attempted murder in the second degree, family or household member, on special verdict form A1, Ihsan Ali is Fatima's father. Everybody says so. Fatima says so, right? In fact, part of the defense that has been provided to you is that they are parents, they are her parents, and so therefore they get to behave in a particular way. So I submit to you this is not an argument between the parties. You still have to find it, again, beyond a reasonable doubt. The parties are not arguing about whether Ihsan and Zahraa are Fatima's parents. So the answer, if you convict on any of those charges, the answer on each of them should be yes. So now we're going to jump over to count 3, unlawful imprisonment of Fatima, again, for both parents. Your Honor, it sounds like maybe we need a break.
All right, I'm going to ask the bailiffs to come forward, and we're going to take a recess for 10 minutes. Remember, you are hearing closing arguments, and deliberations has not begun. You are not to discuss anything during this break. We'll be in recess for 10 minutes.